Well, one of the things that I'm proud to say is that I have an absolutely ironclad practice of assuring that every single penny is accounted for when we settle a personal injury case, and even when we get money before we settle the case. We get money, let's say, from the client's insurance company in Maryland. They have what we call personal injury protection benefits, or PIP for short, and in Virginia they could possibly have the medical payment benefits. Sometimes it's called medical expense, or sometimes it's called MedPay. So I've developed a system, as I believe all attorneys have, or if they haven't, they certainly should, to account for the money and to make sure that the client understands exactly where it is, and what's going to happen. So just moving past the medical payments and the PIP, a check comes in, we've made a settlement of a case, the client is called. Hello Fred, hello Sally, whatever the client's name. As you know, we've settled your case and the check from the insurance carrier has arrived. You need please to come into the office and sign the check. Now why? Because I want the client to see the check. You know, in this day and age, it's not so unusual to imagine that there might be an unscrupulous lawyer. I mean, we know that one has been put in jail recently for any number of fraudulent activities right here in Montgomery County. So, you know, while every lawyer virtually that I know is the most, among they're all honest, they all have a great deal of integrity. You know what? Trust just doesn't cut it in my view. I want the client to see the check themselves. Okay, well, you know what? Sometimes that's impossible. Sometimes the client says, I'm on travel, I'm in California. So what do? I make a copy of the check and I fax it to them, or I scan it and I send it as an attachment by email. The client must see the check. And if it's not in person, where we can then turn that check over and have the client sign it, then they're going to sign the fax and return it to me, or they're going to sign the email and return it to me, giving me permission to sign their name, or even allowing for their father or their mother or their spouse or their child or their friend to come in with a power of attorney and sign their name for them. So that's the very first step. We deposit the check into what is called an attorney's trust account. Every attorney is monitored by their state bar association and must have, when they handle client funds or funds of others, what's called an escrow account or a trust account. It's not the attorney's money. It's a fund, an account that the attorney holds for others. So we deposit that check into the account, we wait for the funds to clear, and when those funds have clear, then we disperse the funds according to what in my office I call a settlement memorandum, which again the client sees, they sign, something that we explain to them and they agree with. So basically it's like a spreadsheet, money in and money out. Here's the settlement, that's the money in. Money out, the lawyer's fee, the lawyer's expense, the medical bills that haven't been paid, bottom line, money to the client. At the end, after I've written all those checks, I make copies of all the checks that I've written so that the client can see that they match exactly to the settlement memorandum. So if I'm supposed to pay Dr. Jones $195.12 on the settlement memorandum, they're going to see a check exactly that amount payable to Dr. Jones with his address on it, that I'm then certifying to the client that I've sent to him in full payment of their bills.